Hey guys, welcome in. It's Ryan and Haley with Ticor Title Talk, and today we're talking about the top 5 pitfalls of title insurance as it relates to probate. We're seeing a lot of probate distress, divorce. Higher percentages of our transactions are related to some form of distress or other in this market. And today we're going to tackle probate. So what's up, Haley?
Hey, what's up, Ryan? Yeah, it is kind of an unfortunate thing that we've been seeing a lot of when somebody doesn't have a estate plan in place or their property's not in a trust, and it doesn't allow us to have the playbook essentially of what happens to the property. So that's what it means, probate, is it goes into in front of a court, in front of a judge, where they have to decide who's going to be the heirs to this property. So some pitfalls, some things that probate and title work together on is number one would definitely be, we look at any liens or encumbrances that are on the title. So anything else that could potentially be on there, any other liens, things like that, we make that aware to everybody.
We curate the title and then make all the obstacles or challenges known to all parties, okay?
Yep, and then number two would be, we identify and make sure that there's no inaccurate or breaks in chain of title. Any uninsured deeds that were done, things like that. If an attorney transferred it into the trust, we have to validate that transfer. If there was any Bobby Sue deeded to cousin Sue, like all those kinds of things, we have to clear up and make sure that there's no breaks in the chain of title and really making sure there's no inaccurate information on there.
It's super critical, the accuracy specifically with all this chat and chatter about, using attorney searches or using other forms of title insurance, and lenders are even exploring that option. And the more you deviate away from a company that's establishing the accuracy and putting their head on the chopping block, like we like to say, you avoid a lot of the erroneous reports and missing of liens that can come up when you're already embroiled in a probate battle, which it can be. Then you have these inaccuracies or these missed liens or encumbrances. Now you're just adding to the challenges, which is probate is, by itself a pretty challenging transaction.
I mean, it could be a 6-month process all the way up to 2, 3, 4-year process, depending on how people are working together, how the heirs are handling the situation. So it could be a long, drawn-out process. So something else that title does when we work with the probate attorneys or in probate, we acknowledge if there's any exclusions or limitations. So on your preliminary report, you see exclusions, limitations, those kind of things. So if there's any zoning violations or if there's any boundary disputes or things like that, we make that a light and we bring that up in the report as well. So that's something else that we're acknowledging on what's on there, like hazardous, environmental hazards, that kind of stuff.
And a lot of times boundary disputes come up and it's something that isn't covered by title. We cover the legal description of the property. We can point out where we believe the property lines to be, but an engineer gets out there and that's what holds up in court is the survey, which is the report an engineer delivers in that circumstance. So. Good stuff.
Yeah.
Does that bring us to 4?
Yeah, so on 4, it's, a lack of probate planning. So this is a big one because if you don't have your probate plan or your trust in place, there's so many things that could come up. Disputes between heirs, we have increased cost. I mean, you think about it, it's not cheap to go into probate. You have to pay an attorney, you have to pay fees, all the different accumulated costs that go into it where it's not a very cheap expense to go into probate. It could be eating away at all the proceeds to the sale of the property.
Definitely taking a huge chunk out of the administration of the estate.
Exactly. So that's something else that, to have your estate plan, to make sure your property is in the trust, that will eliminate a lot of those hardships on there.
We say it, an ounce of prevention is worth a pound of cure, or fail to plan to fail. It takes a little bit of effort, a little bit of time, but I can tell you that leaving a playbook when you're no longer walking the face of the earth can save your heirs a ton of heartburn, heartache, and money.
Yeah.
So that's a good one.
And then number 5 is contesting wills and estates. So we get this a lot. They have a will, they have a last will and testament. Does that hold up? This can't be probate. And unfortunately, a will does not hold up as a holding title It does not hold up on a way to be able to actually transfer the property. So a will allow the judge to kind of have an idea of what they wanted, but it really doesn't hold up as a solid trust or a solid foundation in a real estate transaction.
So many of us think we're covered because we have a last will and testament of our wishes beyond our grave, and it just can be influential with the judge, but the judge, it's on him to decide what the right thing to do with your assets, and that's property, jewelry, family heirlooms, all of that. You're leaving that in the hands essentially of a stranger. So one bit of advice is to plan and have a written plan in the form of an estate and trust, revocable trust, irrevocable trust. We have people we can send you to have further discussions on that. And your future self and your future kin will be thankful that you did that.
Yeah, I mean, I've heard it before, just out talking to people like, oh, well, they can deal with it when I die. Like, it's fine. Do you really want that though? Do you want your children fighting? You know, who knows what's going to happen 10, 15 years down the road? Like, do you really want them going head to head? And it could tear up, I've seen this tear up families. I've seen it get really, really intense. So just do a little bit of planning. They ask you some questions that are a little morbid on getting the trust plan, but it goes so much further down the line where you can actually transfer your property to your next of kin, your heirs, without having any heartaches or issues from the grave.
Well said. And there you have it, the top 5 pitfalls for title insurance and probate scenarios. A little bit of planning goes a long way. If you have any questions, if you need
no pun intended.
But this is your legacy, and this is how you can protect it. So until next time, she's Haley, and I'm Ryan.
Bye.
Bye.